The defense has you examined by a doctor of their choosing who then confirms that you have a significant injury. Can you use that confirmation as evidence in your case at trial? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is no, we can't use that report to get into evidence. But what we can do is we can use the information in that report to get that out during testimony when we question the defense doctor. So let me explain what happens. So now you've brought a lawsuit seeking compensation for the injuries that you suffered because of someone else's carelessness, their negligence. Let's say it was a careless driver, or maybe a careless doctor, or maybe a careless company. And now you bring that lawsuit. The defense now has an opportunity to have you examined by a doctor of their choosing. Their whole goal is to determine whether or not your injuries really are as bad as you claim them to be. Their whole goal, their agenda, is to try and minimize whatever injuries you have. So now you go for that examination. The doctor's not there to treat you. He examines you, and he does confirm in his written report that your injuries are very significant. Can we now take the defense doctor's report and give it to the jury at trial to show as evidence that your injuries really are as bad as you are claiming? The answer is no, we can't get that report into evidence. What we can do, however, is when the defense doctor gets up to testify, now I can ask him anything that's contained in his report and more. And you better believe that during the course of my cross-examination of the defense doctor, I'm going to spend a considerable amount of time on the fact that his entire goal, his entire purpose, is to confirm or validate or invalidate whatever injuries you had. And now I'm going to take him through his examination and his conclusions about what he reached as a result of that exam. And if he reached and determined that your injuries truly are very significant, I'm going to have him go through it every step of the way to explain to the jury why he believes your injuries are significant and permanent. That is something I can do. But just to take the doctor's report, admit it into evidence, and now hand it to the jury, it doesn't do justice. Plus, the best person to explain the information contained in his report is right there in front of us. And I'm going to have him, the doctor, the defense doctor, explain to the jury why the injuries are significant and permanent in order to bolster our case, in order to bolster the injuries that you've suffered, to get the jury to understand how badly you were injured. So why do I share this great information with you? I share it with you just to show you one trial strategy that occurs when a defense doctor gets on the witness stand to talk about the examination he conducted of you during the course of your lawsuit. You know, I realize you've got questions and concerns about your own particular matter. Well, if you're contemplating bringing a lawsuit and your matter happened here in the state of New York and you've got questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.